Yes, Mr. Hill.
Today, so we move on to the presentations from Counsel to the inquiry on the pharmaceutical companies. That will be the pattern of work for the next couple of weeks. Before turning to the individual companies, we thought it would be helpful to present an overview of the licensing regime as it stood in the 1970s and the 1980s in particular. This is an attempt to assist everybody in understanding what is coming next. It is not a comprehensive discussion of all aspects of licensing. That would take many days and perhaps wouldn't be of such great assistance. Instead, this is intended just to give a neutral overview to assist in understanding the presentations and the evidence that is going to follow in the next couple of days and weeks. Further evidence about the licensing regime is going to be heard by you later in this inquiry, and this presentation is not intended in any way to preempt that evidence. And it may be that things that you hear subsequently change your view of what we are saying today. A helpful overview of the regime was provided in the evidence of Lord Fowler and in his witness statement. And Lord Fowler said in his statement that he was drawing on the findings of the BSE inquiry, and particularly Volume 7, Chapter 2. That described the position in 1988 to 1989. Lord Fowler's understanding was that, in broad terms, that was an accurate summation of the situation before that as well, and that is also our understanding. And so as to avoid reinventing the wheel, I'm going to read from that statement to provide the initial overview, and then we'll go through in a little bit more detail some of the points. So, Nick, can we have on screen, please, WITN 0771001 on page 35. So this is the evidence of Lord Fowler in his written statement. What he says about the regime is this. Point 1. The licensing regime was established by the Medicines Act 1968. In essence, a medicinal product could not be sold unless it had been granted a product license by the licensing authority. The licensing authority was, in principle, the relevant minister, although in practice, his or her functions were delegated to officials in the Medicines Division of the Department of Health, Medicines for Human Use. They received advice from a number of committees of experts set up under Section 4 of the Medicines Act, known as the Section 4 Committees. Responsibility for the granting, renewal, variation, suspension, and revocation of licenses was given by the Medicines Act to the licensing authority. Under the Act, the health ministers and the agricultural ministers, i.e. the Secretary of State for Health, the Minister of Agriculture, Fisheries and Food, and the corresponding ministers in Northern Ireland, Scotland and Wales, comprised the licensing authority, although any one of them acting alone was permitted to perform its functions. In practice, the functions of the licensing authority in relation to medicines for human use in the UK were, throughout the period 1985 to 1996, performed by the Secretary of State for Health. I will come back to that date, but I think that is just an artefact of the report and is something which also applied to the earlier period as well. Although formally the Secretary of State for Health acted as the licensing authority for human medicines, in practice his or her functions were delegated to officials working in the Medicines Division of the Department of Health and, after April 1989, officials working for the Medicines Control Agency, or MCA, subject to the normal legal principles relating to the extent to which ministerial functions may be delegated. The arrangements meant that product licenses were physically granted by officials, not by the minister, although I remained accountable for them. The Medicines Act 1968 required that ministers establish a medicines commission made up of professionals with, quotes, wide and recent experience in the practice of medicine and pharmacy. The Commission was required to advise the ministers making up the licensing authority on matters relating to the execution of the Act and on medicines generally, where the Commission considered it expedient or when requested by ministers. It also acted as an appeal body in respect of advice given to the licensing authority by the Section 4 committees. The Committee on the Review of Medicines, CRM, was established to review the safety, quality, and efficacy of medicines that had been on the market before the Medicines Act introduced licensing requirements. At that time, these products were granted licenses of right. The Committee on Dental and Surgical Materials, CDSM, advised on questions of the safety, quality, and efficacy of dental and surgical materials. The Committee on the Safety of Medicines, the CSM, advised on questions on the safety, quality, and efficacy of human medicines that fell outside the remit of the CDSM and the CRM. The Biological Subcommittee was one of the subcommittees reporting to the CSM. The licensing authority was required to consult a relevant section committee, or, if there was none, the Medicines Commission, in certain circumstances. For example, when it was minded to refuse an application for a product license or to suspend, vary, or revoke a license. Otherwise, officials had a discretion whether to seek advice from the Section 4 committees in relation to any particular product. The licensing regime for human medicinal products was operated by officials in the Medicines Division in the Department of Health and Social Security. The division was organised in 3 parallel structures: medical staff, pharmaceutical staff, and administrative staff. Responsibility for staff in these structures was essentially divided along professional administrative lines. The professional staff reported to the Senior Principal Medical Officer, SPMO, or the Chief Pharmaceutical Officer, and the administrative staff reported to the Undersecretary. The National Institute for Biological Standards and Control, NIBSC, was established under the Biological Standards Act 1975 in order to secure high standards of quality, safety, and efficacy and consistency of biological substances used in medicines. In fulfilling this role, it devised standards for the quality, purity, and potency of biological substances, tested batches of biological products on behalf of the DHSS, carried out research, and advised a number of bodies, including Medicines Division of DHSS and its Section 4 committees. NIBSC staff were members of the BSc and the CSM. EC regulation of human medicinal products was introduced with the adoption of Council Directive 65/65/EEC. That was introduced on the 26th of January 1965, so before the United Kingdom entered what was then the European Economic Community. Its framework was similar to that of the Medicines Act. It was based on the grant of a marketing authorization by a competent authority of the member state in question, i.e. a decentralized system. No product within the scope of the directive could be placed on the market in a member state unless an authorization had been issued by the competent authority of that member state. No new legislation was introduced to implement Directive 65/65/EEC. I take that to mean no new legislation within the United Kingdom. The competent authority of the United Kingdom for the purposes of the directive was the licensing authority. Additional measures were introduced in 1975, including mechanisms for the recognition by all member states of product licenses granted by any individual state. The Committee for the Proprietary Medicinal Products, CPMP, a scientific committee, was also established. This advised the Commission, I pause there to note that that's the European Commission, on issues of safety, quality, and efficacy in much the same way as the CSM advised the licensing authority in the UK. This chapter of the BSc report goes on to refer to the Evans-Cunliffe report commissioned in 1987. That is something, sir, that we will come back to shortly. That, sir, is where I leave Lord Fowler's evidence, the key points that we take from that evidence on the structures are these. First, products were licensed by the licensing authority. In particular, that was a reference to the Secretary of State for Health, but also other ministers. In practice, the function was delegated to officials working within the Medicines Division of the DHSS. From 1989, the functions were undertaken by the Medicines Control Agency, following a reform of the Medicines Division. The Medicines Control Agency was a self-financing agency within the Department of Health. Those officials to whom that function was delegated could take advice from what were referred to as the Section 4 committees. They were listed in Lord Fowler's evidence, but for our purposes, the key ones are the Committee on the Safety of Medicines and the subcommittee, which is the Biological Subcommittee of the Committee of Safety of Medicines.
The Biological Subcommittee was a subcommittee of the CSM.
That's right.
So it would give its advice or recommendation to the CSM, and the CSM would, as a Section 4 committee, give its advice to the licensing authority. Is that correct?
That is correct, sir. We will come on to a little bit of evidence from Sir Joseph Smith shortly that describes that in practice. There was also a body called the Medicines Commission. This also provided advice, including on how to set up the Section 4 committees and what they should be doing and how they should be constituted. It also acted as a de facto appeals body if the CSM or the CSMB advice was to reject an application. The company could then appeal to the to the Medicines Commission. In addition to those bodies...
What was the effect if it allowed an appeal?
The effect would be that its advice to the minister would be that, for example, a product license should be granted. But ultimately, the licensing authority would be the one that was taken.
So ultimately, the minister or the licensing authority, all the ministers who composed that authority, would have to make a decision.
That's right.
Did it ever happen?
There were certainly appeals to the Medicines Commission. I can't say off the top of my head how many of those were successful and what the outcome of those was. As it was advisory, it would not necessarily be a firm appeal allowed or appeal dismissed. It may be our advice is that further information needs to be gained on this particular topic, but if that information is gained, then we would recommend that a license be given. So it's not a judicial body, as it were, saying yes or no. Instead, it's got a wider remit. In addition to those bodies, there is the National Institute for Biological Standards and Control. This was established under a separate act, but it carried out certain functions which are relevant to licensing. It provided advice to the CSM and the CSMB. The staff from the MIBSC might sit on some of the Section 4 committees, and it would also carry out testing, for example, as part of the licensing process. That, sir, is the outline. I would like now to just go into a little bit more detail about some of the provisions of the Medicines Act 1968. And you'll be pleased to hear, and I'm sure everybody will be pleased to hear, that I don't intend to go through every one of the 300 pages of it. But we will just pick up a few of the points from it. First, the question of what factors were relevant to determining the application for a license. Section 19 of the Act provides a non-exhaustive list, and the three key themes are safety, efficacy, and quality. And you will have heard those mentioned in Lord Fowler's evidence. That's found in Section 19.1. Those are also the three areas on which the Section 4 committees were permitted to advise. That is Section 4.3a. For imported products, the licensing authority would also consider, and I quote, the methods, standards, and conditions of manufacture of those products. That's Section 19.3. a manufacturer's operations, premises, equipment, and the qualification of its staff and of its record keeping were also to be considered. That's section 19.5. That is, as I say, a non-exhaustive list. There isn't a single checklist which the licensing authority had to go through, but those are matters that the legislation said that it should consider when fulfilling its functions. The Act also specified certain factors that the licensing authority should not take into account. Section 22, that's 20 brackets 2, provided that the licensing authority could not refuse a license on the grounds of price and cannot make a license provisional on the product being sold at a particular price. So it is not the function of the licensing authority to try to regulate the price of the medicines. Section 19.2 provided that when assessing how efficacious the product is, efficacious is the word used in the Act. I take it to mean how effective the product was at doing what the product should be doing, so how effective the indigestion pill is at getting rid of indigestion. When assessing how efficacious the product is, the licensing authority should not take into account whether or not another product is equally or more efficacious, although when it's discussing or considering the safety of a product, it could take into account the fact that a safer product was just as effective or was more effective. So the licensing authority is not there to say, we're not going to license this product because there is another one that does the same thing just as well. But if there is a safety concern, that is a matter that it could take into account. The next point that I would turn to is something that was mentioned by Lord Fowler, that the licensing authority shall not refuse a license on grounds of safety, quality, and efficacy without consulting the relevant Section 4 committee or, if there wasn't time, the Medicines Commission. Now, that's in Section 20, brackets 3. That meant that the Medicines Division could grant a license without consulting the Section 4 committees, but it couldn't refuse one. And that may be of some relevance to something that comes up later in the presentations. The licensing authority can make a license provisional on undertakings from a manufacturer of an imported product. And some of the types of undertaking that could be sought were given in Section 19, brackets 3 of the Act. They are things like the license won't be granted unless the manufacturer of the product gives an undertaking to permit inspection of the manufacturer's premises by or on behalf of the licensing authority. The undertaking could be to comply with certain prescribed conditions that are part of the license, but as we've seen, you can't use that to get around the prohibition on setting the price of the product. The undertaking might be to give a declaration that the product complies with the laws of the country in which it is manufactured. The length of time that the license lasts was set by Section 24 of the Act. The rule was that a license granted under the Act would last for 5 years. The license holder could apply for it to be renewed. Where an application under the Act for renewal had been made, then the license, and I quote, shall not cease to be in force before the licensing authority have determined the application. That's Section 24(6). The inquiry's understanding of these provisions is that if a product was granted a license in, say, 1975, that license would run until 1980. If before 1980 the license holder applied for a renewal, then the product would continue to be licensed until that application was considered and decided, even if that ran past 1980. In such circumstances, and we will see this in some of the papers that we look at shortly, the renewed license would run from the time of the expiry of the old license rather than the time that the decision was made. As I say, so that is our understanding. There may be further evidence that you hear on this which changes that understanding. But at present, that is how we understand the process to have worked. There was a power to suspend, vary, or revoke a license subject to the procedures set out in the Act, and that power and those procedures are found at sections 28 to 30. A license could be suspended, varied, or revoked on a number of grounds, including that the application for the license was false or incomplete, section 28(3)(a), that there had been a material breach of the provision of the license, section 28(3)(b), and I quote here, the medicinal products of any description to which the license relates can no longer be regarded as products which can safely be administered for the purposes indicated in the license, or can no longer be regarded as efficacious for those purposes. And that's section 28(3)(g). I also note, sir, that appropriate ministers were given powers to make regulations governing product labelling and packaging, and those powers were backed by a criminal sanction for some breaches. That's at sections 85 to 91. That is the overview of how products would be licensed under the Act, but it's important to note that there are exemptions which are contained in the Medicines Act 1968 as well. The position was that without a license, a company was in effect prohibited from selling, supplying, exporting, or importing a product unless one of these exemptions applied. The prohibition is found in section 7. For the inquiry's purposes, 2 exemptions are of particular relevance. The first is the named patient basis, and the second is the clinical trials exemption. We turn first to the named patient basis. The Act allowed doctors and dentists, there's also some provisions for pharmacists as well, but for the purposes of simplicity, so I'm just going to refer to doctors during this presentation. So the Act allows doctors to import a medicinal product to his order, and I quote, for administration to a particular patient of his. That's at section 9(1) and a similar provision at section 13(1). So the doctor can import a product without a license if it's to be administered to one of his patients. The gender is expressed in the Act. In November 1978, so that was the basic position as set out in the 1968 Act. In November 1978, certain restrictions were introduced on products imported under a named patient basis by the Medicines Exemptions for Licenses Importation Order of 1978, that is SI 1978-1461. In brief, those restrictions were that the importer of the product had to inform the licensing authority within 21 days of the first receipt of the product. That's Article 3A. Second restriction was that no advertising or representation was allowed for such products. They could only be provided, and I quote the statutory instruments, in response to a bona fide unsolicited offer. The third restriction is that written records should be kept and maintained and would be made available to the licensing authority on request. So that is 1978, 10 years after the initial Act. You see the introduction of this order to put in place those provisions. From June 1984, further restrictions were introduced in the form of the Medicines Exemption from Licenses Importation Order 1984. And it might be helpful to have this on screen, please, Cernic. It's PRSE 40177. We look first at the top of the statutory instrument. You can see its title. And you can see that it was made on the 14th of May 1984. It was laid before Parliament on the 16th of May 1984 and came into operation on the 6th of June 1984. Then you can see underneath the various ministers who have been involved in the implementation of this legislation. And as per Lord Fowler's statement, the first reference is the Secretary of State concerned with health in England, and then the Secretaries of State respectively concerned with health and with agriculture in Wales and in Scotland, Minister of Agriculture, Fisheries and Food, Department of Health and Social Services for Northern Ireland, and the Department of Agriculture for Northern Ireland, acting jointly in exercise of powers conferred by the Medicines Act, have made the order that follows. Further works will be undertaken on trying to understand how the Act operated in practice across the 4 countries of the United Kingdom. But it can be seen here that there is a joint and a central approach to this piece of legislation. And it is our understanding that most licensing decisions were taken centrally, most were taken within the Department of Health. We will look to see whether or not there is any variation over the course of the evidence that we hear. If we turn, please, Cernic, to the second page. We can see that this is referring back to, it is statutory language, and it refers back to the previous articles within this order and indeed to the Act. And it's talking about the exemption on the named patient basis. The first point that I would draw out is that you can see in 4.1a that there is now a requirement that in order to make use of the named person exemption, the person importing a medicinal project which is the subject of that exemption has given or sent to the licensing authority prior to each such importation a notice in writing which states his intention to import that medicinal product for sale or supply in the circumstances specified. So whereas previously the requirement was to let the licensing authority know once you have received the product, now you have to give prior notice. We can see in 4.1a, 1, 2, 3, and 4, some of the information that you needed to provide when given that prior notice: the name of the product, each active constituent. And then at point 3, and this is important because it's introduced by this Act for the first time, the quantity of that medicinal product which is to be imported. And then the name of the address of the manufacturer. Then on to 4b. The person importing a medicinal product which is the subject of that exemption has given or sent to the licensing authority, together with the notice referred to in paragraph 1a, an undertaking in writing, 1, that the quantity of that medicinal product which is imported in accordance with the notice referred to in paragraph 1a does not exceed such quantity as will be sufficient for 25 single administrations or for 25 courses of treatment not exceeding 3 months. Again, sir, this is a new provision which is introduced in the Act, and you can see that the effect is to limit the amount of product that can be imported on a named patient basis. Our understanding...
on one occasion.
Precisely, sir. Our understanding of that is that it is 25 courses of treatment for that named patient. So if you have 2 named patients, then you can have another 25.
But is there anything to stop the clinician concerned, as he gets towards the end of the 3 months, saying, I'm going to do this for another 3 months?
No, but it would require...
further communication?
Yes.
So it requires further writing of letters?
Yes. But what it does allow for the first time is for the department to be aware, if it is able to trace through those letters, of the quantity of material that is being imported on the named patient basis. So far as I'm aware, the previous legislation, primary and secondary, didn't allow for that. The next provision is that the person seeking the exemption will inform the licensing authority forthwith of any matter coming to his attention which might reasonably cause the licensing authority to believe that the medicinal product can no longer be regarded either as a product which can be safely administered to human beings or as a product which is of satisfactory quality for such administration. And again, so that is a new provision, and you will see that it echoes, not precisely, but it echoes the wording of the 1968 Act about when you can revoke or vary or suspend a license. The next provision, this is an updating of the provision that was in the 1978 order. And I quote, "He will not at any time issue or cause another person to issue any advertisement or make any representation in respect of that medicinal product, and that he will sell or supply that medicinal product only in response to a bona fide unsolicited offer." Then the next provision is about written records, and you can see that it goes into more detail than the 1978 Act does about what those records should contain. That includes the name and quantity of a medicinal product, the name and address of a manufacturer, and if different, the supplier, the assembler. In respect of a supply or sale of that medicinal product, specifying the name and address of the person to whom the medicinal product is sold or supplied, the quantity and the date of such sale or supply. And there is also a provision that follows that those records should be kept for 5 years. The next article to which I will draw your attention, sir, is 4C. And this is, again, a requirement in order to get the exemption, and for the exemption to hold. I quote, "The licensing authority have not, before the end of a specified period, given or sent to the person proposing to import that medicinal product a notice in writing stating that the provisions of this order shall not apply to anything which the said person proposes to do which consists of importing, selling, or supplying that medicinal product because, 1, any conditions specified in the preceding subparagraphs or of this paragraph is not satisfied, or 2, the licensing authority have reasonable cause to believe that the medicinal product cannot be regarded as a product which can be safely administered to human beings or is not a product which is of satisfactory quality for such administration."
So this is the teeth which the authority has in respect of prior notice. So instead of telling the authority you brought the product in and may well have used it, you now have to say, I'm going to do it, and the authority can say, well, sorry, this order doesn't apply. If the order doesn't apply, you don't have exemption. If you don't have exemption, you can't do it.
That's correct, sir.
Right.
The following provision is that the specified period means 28 days. So the person seeking the exemption provides the notice. If within that 28 days the licensing authority doesn't do what you have just said, then the exemption will apply. So it's not a case that you have to wait for the licensing authority to say yes.
They've got to act fairly quickly.
Yes. So, final point I would draw your attention to, Article 6 of the order, right at the end. You can see the medicines exemptions from licensing importation order 1978 is revoked. That was the previous order that we were talking about, so this supplanted it. And we will see that it is signed by Kenneth Clarke, Minister of State for the Department of Health and Social Security, and then the Secretary of State for Wales, Nicholas Edwards, George Younger, Secretary of State for Scotland, Michael Joplin, Minister of Agriculture, Fisheries and Food, the Permanent Secretary at the Department of Health and Social Services for Northern Ireland, and the Department of Agriculture for Northern Ireland, Under-Secretary. So that then is the 1984 order. You may feel so that in the...
do we have any information as to why, only 6 years after the earlier order, this was introduced?
It is something so that we will be exploring, a theme to explore during the presentations that we're about to embark into.
I mean, it gives rise to a suspicion that the department thought that there might be good reason to control the named person exemption, because it had led, in some cases it was thought or suspected, to unsafe products being used.
I would agree with all of that, so save for the question about whether or not unsafe products were used. There may be a feeling that it has been used to circumvent the licensing procedure too much. That could give rise to the use of unsafe products, or it could just be a concern that there is a potential or a risk of products which haven't gone through the same checks for safety, efficacy and quality are being imported into the UK market.
I wasn't suggesting it was an inference that could be drawn, but I was suggesting that at least it opened your eyes to the possibility that might have been in the minds of those who were proposing this order.
Certainly, sir, and there is evidence that you will hear in the coming days which I think supports that. And obviously, others will have their own view of that evidence, but it will be my submission that there is evidence that supports that.
Thank you.
If we turn away from the named patient exemption to the second exemption, and that is clinical trials. The 1968 Act set out at Section 31 and Sections 35 to 39 a regime in which a clinical trial could be undertaken. These were supplemented over time by various orders made by ministers, including the Medicines Exemption from Licenses Clinical Trials Order of 1974, which is SI 1974-298. I won't try, sir, to take you through all of the relevant provisions, but the initial position under the 1968 Act was that a product could be used in a clinical trial if, firstly, a product license authorised its use in that trial, so there was an actual license which said it could be done. That's Section 31(4)(a). Or if a clinical trial certificate, sometimes referred to as a CTC, was issued, so that's Section 31(4)(b). So the person who is seeking to include the product in a trial applies for a certificate rather than a license. Sections 31(5) and 31(6), in our understanding, allow a product to be used in a clinical trial on a named patient basis. So if you are importing the product on the named patient basis, that patient can be entered into a clinical trial. And under Article 2(4) of the 1974 order, if a person intending to sell, supply, or import the product notified the licensing authority of a proposed clinical trial and provided details of it, and the licensing authority had agreed to that exemption, and the product could be used as well. So that's not a certificate, it's not a license, it's a notification and agreement procedure. In March 1981, the regime was changed by the Medicines Exemptions from Licenses Clinical Trials Order of 1981. That introduced a clinical trials exemption scheme, sometimes referred to in the papers as a CTX, whereby the licensing authority could exempt a supplier of a product from the need to hold a clinical trial certificate for 3 years if certain undertakings were given. It's Articles 3 to 5 of the 1981 order. The supplier would apply for the exemption, providing details of the product and the trial, together with a certificate signed by a doctor. That's Article 4. There would be a period of 35 days in which the licensing authority could inform the supplier that the scheme did not apply, and at the end of that period, the exemption would take effect. It's Article 4. So again, a similar negative consent procedure rather than positive assent. The supplier was required to inform the licensing authority of any adverse reactions or other matters that might reasonably cause the licensing authority to think that the product was not safe or satisfactory. That's Article 4(1)(c), again, similar to the 1984 order that we have just looked at.
In advance or in retrospect?
The adverse reactions obviously has to be in retrospect, but any other matter that might reasonably cause the licensing authority to think that the product was not safe or satisfactory, that would seem to be an ongoing obligation. The licensing authority had powers to terminate the exemption, including on grounds of safety, and that's Article 5(2). So you may feel, sir, that in contrast to the named patient basis, where we see a tightening of the restrictions, there is a greater degree of flexibility which is introduced by these orders over time in terms of the clinical trials process. So those are the legislative provisions. So I'm now going to turn to a little evidence about how the process operated in practice. And it's intended to provide an introduction about the general structures and processes. Further evidence is going to be called in due course, and you will, of course, want to consider all of that before making any findings. This is really just by way of introduction. The first bit of evidence, please, Sir Nick, is WITN 5281001. This is the written statement of Sir Joseph Smith, dated 25th of June 2021. This version, sir, is the unsigned but approved evidence that we disclosed prior to witnesses giving evidence in the summer. For these purposes, I don't think it matters, so I don't think that this evidence is in any way contentious. It is merely Sir Joseph discussing some aspects of how the licensing process works. If we could turn first, please, Sir Nick, to page 3, in paragraph 0.2, we can see Sir Joseph setting out the positions that he held. He was the director of the National Institute for Biological Standards and Control, that's NIBSC, from 1976 to August 1985. He was the director of a public health laboratory service from August 1985 to 1992. He sat on the Committee on the Safety of Medicines from 1978 to 1986, and he was the chairman of the Committee on Safety of Medicines Subcommittee on Biological Products from 1981 to 1986. You've heard evidence of the meeting of the 13th of July 1983 of the Committee on the Safety of Medicines Biological Subcommittee, and it was Sir Joseph who was in the chair at that meeting, where the steps in response to AIDS were discussed. If we could turn to paragraph 2.7, which is give me something, it's on page 8. Sir Joseph describes the way in which the work of the NIBSC was divided. We go down to 2.9 on the same page. He talks about the wide variety of different biological products necessitated a corresponding range of scientific disciplines at the NIBSC. During my time as director, the Institute had 5 scientific divisions, and he lists them. For our purposes, the important one is blood products. He then goes on at the bottom of that paragraph on the next page to talk about how the work of that department can be broadly divided into 3 areas: standardization, control, and research. For today's purposes, it is the control work of the NIBSC which is of interest to us. That is at 2.11. If I read from his statement, he says, "The control work of the NIBSC included the evaluation of medicinal products both before and after licensing, and advice was given to the licensing authority and the Committee on the Safety of Medicines on applications for product licenses and clinical trial certificates for biological products. The NIBSC also had a part to play in the batch release process, which was applied by the licensing authority of the DHSS to manufacturers of certain biological products and required them to submit to the NIBSC on a batch-to-batch basis protocols describing the results of in-process tests made during the manufacture and, in the majority of cases, samples of all such batches. The samples could include, in addition to the finished product, bulk and in-process materials, the control of which is essential to ensure the quality and safety of biological medicinal products. A batch release order could require that marketing or supply of any batch shall not take place without the issue of a formal release certificate by the board on behalf of the licensing authority. This type of order was known as a full stop order. Such orders were usually judged to be necessary for new biological products and sometimes remained in force permanently, as in the case of potentially hazardous products, such as live virus vaccines. In other cases, satisfactory control could be maintained by scrutiny of protocols only. Once satisfactory evidence had been provided that the manufacturer produced a product of consistently acceptable quality and related safety, a batch release order might have been partially relaxed or completely withdrawn. The testing carried out by NIBSC on biological products used in human medicines included testing against the appropriate biological standards, the potency of submitted batches of biological products, which were the subjects of a UK product licence or clinical trial certificate application of the United Kingdom, but may also have included other tests relating to the purity and potency of the product. He addresses those in paragraph 2.20, which I won't take you to yet. Paragraph 2.15, please, Sir Nick, on the next page. This is about the Blood Products Division. Sir Joseph said this: the Blood Products Division was established as a separate entity within NIBSC on the 1st of October 1976 with the appointment of Dr. Duncan Thomas as its head and the transfer of scientific and technical staff from a former division of hormones and blood products, which, until then, had been responsible for control of hematological materials. When I was director, the Blood Products Division was responsible for controlling certain blood products, for preparing international and British standards, and for carrying out related research. I'll turn now to paragraph 2.20, to which Sir Joseph made an earlier reference. This is, again, about the work of the Blood Products Division. What he says is this: apart from testing the purity and potency of samples of blood products examined by the NIBSC, tests for thrombogenicity, the tendency of a material to generate blood clotting and or thrombus when in contact with the blood, could be carried out. as well as tests for certain blood-borne infections where these were available. For example, when I was director, samples were tested for hepatitis B antigen, and later when a test became available for HTLV3. It appears from the Nibsc report from April 1984 to March 1985 that samples were being tested for HTLV3 by this time. Follows a quotation from the report, which says a total of 124 batches of manufacturers' products were submitted, a slight fall from last year, which was probably mainly due to the switch by manufacturers at the end of 1984 to Factor VIII preparations subjected to heat treatment. The batches included 18 from the Blood Products Laboratory, Elstree, and 10 batches from the Protein Fractionation Centre, Edinburgh. Tests at Nibsc on these materials gave negative results for HDLV3 and hepatitis B. Turning to the remit, functions and activities of the Committee on the Safety of Medicines and the Biological Subcommittee and his roles on those committees, Sir Joseph says this. The CSM's primary role was to consider questions relating to medicines licensing. The CSM would regularly consider applications for product licenses and clinical trial certificates made by drug manufacturers. These applications, including applications to vary existing product licenses, as well as applications for product licenses for new products, were referred to the CSM by the licensing authority, strictly speaking the Secretary of State, but in practice the Medicines Division of the DHSS. Applications for consideration by the CSM went in the first instance to the Secretariat of the CSM and would then be presented to the appropriate subcommittee. The main subcommittee dealing with most pharmaceutical products and a second subcommittee dealing with biological products, the CSMB. As explained above, biological products were products which could not be assessed by physical and chemical means alone and required biological standards against which to measure their potency. This would include vaccines, certain antibiotics, hormones, and blood products. The CSMB was composed of senior members with expertise appropriate to its work, that of assessing the safety of biological medicines and their risk-benefit balance. They were experienced in assessing the necessary biological, clinical, and epidemiological evidence contained in the cases submitted for their consideration. Their expertise included clinical infectious diseases, clinical and experimental virology and bacteriology, hematology, endocrinology, epidemiology, and the production of biological medicines. The subcommittee's evaluations also benefited from the assessments made by the medical and scientific staff of the Medicines Division of the DHSS, as well as the views of the professional staff of the Nibsc. The advice of the administrative and legal staff of the Medicines Division could also be taken into account, particularly regarding requirements of the Medicines Act, for example, the need for confidentiality. The conclusions and recommendations of the CSMB would accompany the application papers when they were considered by the CSM. The CSM would in turn make recommendations to the licensing authority. That is, as we discussed earlier. I would also draw your attention to a little later in the statement, paragraph 3.53 at page 44, please, Sir Nick. This is a further comment that Sir Joseph Smith makes. This is in the context of the 13th of July 1983 meeting, but from the way the evidence is presented, I think that it has a wider relevance as well. Paragraph 3.52. I am asked at question 12B, that is a Rule 9 request that we sent him.
We're on the wrong... Thank you.
Thank you. I'm asked at question 12B what, if any, discussion there was at the CSM of the CSMB conclusions, and if there was any discussion, whether there is any reason why it was not recorded in the minutes. As I say, so that relates to the 13th of July meeting. I cannot recall there being much discussion on this occasion, or indeed on other occasions when the CSMB presented recommendations to the CSM. Although the CSM would have read carefully any written information provided, CSM members generally agreed with the CSMB in relation to its recommendations.
So, in effect, it was a nodding through type process.
After consideration of the papers, yes.
Yes, they'd read the papers.
They've read the papers.
Or had the papers to read anyway.
You will have further evidence from people who worked both on the CSMB and worked with the CSMB, which will, we hope, provide more information about how things worked in practice. That is the evidence that we have from Sir Joseph at this point. The final piece of evidence that I would draw your attention to, sir, at this stage, is the Evans-Cunliffe report, which was mentioned in Lord Fowler's evidence. So, Nick, can we have, please, WITN 0771006? This is the front page of the report, and you can see it's by Dr. Evans and P.W. Cunliffe, published in December 1987. If we go to page 10, please, Sir Nick. We can see the context of the report. And I read from it. Introduction. In the spring of 1987, the Medicines Act 1968 was almost 20 years old. The Medicines Division of DHSS, which is the government department charged with the implementation of licensing of medicines under the Act, was showing signs of overload. We were asked by ministers to study the arrangements for the control of medicines with the following terms of reference. Quotes, to examine the issues for DHSS arising from the continued increase in licence applications and other work under the Medicines Act, and to recommend ways of dealing expeditiously with this work, while maintaining adequate standards for the safety, efficacy, and quality of human medicines in the United Kingdom. So that is what they were asked to do and why they were asked to do it. If we could turn, please, to paragraph 2.2. This gives a little insight into the size of the Medicines Division at the time. Sorry, for page 11. Thank you, Sir Nick. Paragraph 2.2 says, in all these activities, the greater part of the work in assessing applications and in issuing licences on behalf of ministers is done in the Medicines Division of the DHSS, assisted by the Medicines Commission and a number of expert statutory committees, the Section 4 committees, of which the Committee on the Safety of Medicines is probably the best known. Medicines Division comprises some 300 civil servants, including 165 administrators, 97 pharmaceutical staff, mainly pharmacists, and 24 doctors, the most senior being 2 Grade 3 officers, namely a senior principal medical officer and the administrative under-secretary. I don't go to it now, sir, but table 3 at page 54 of this report contains more of a breakdown of how the size of a Medicines Division changed over the years. A little further down page 11, you can see the problem that had given rise to this report. This paragraph says it's also instructive in terms of the different types of licenses that could be applied for. It's not a case where there was simply one form of application. What the report says is this: there has been a progressive increase in the number of applications. Analysis is complicated by several factors, viz. 1. Different kinds of application impose quite different burdens upon the division. The assessment of a novel kind of medicine, a, quote, new active substance, usually requires much more work than does that of a simpler, abridged application for a medicine based on familiar active ingredient. Clinical trial certificates and exemption certificates, variations and notifications are different again. I pause there, sir, just to point out some of that terminology, the abridged application and the applications to vary an existing license. Two different matters to a new active substance license, which requires consideration from scratch. If we go over to subparagraph 3 on the next page, please, Cernick. Further evidence of the complexity. The report says, even within one category, say abridged applications, there are marked differences in the complexity of the professional work needed in the division. Such differences are hard to quantify, but the industry and DHSS staff agree that both new active substances and major abridged applications are steadily becoming more complex. For example, medicines produced by recombinant DNA techniques present the assessors with quite new kinds of problems to solve. Reading on, the report's authors say, Table 2 shows DHSS figures for the number of applications received each year from 1976 to 1987, without attempting any correction for this increase in complexity. The growth overall approximates to 5% per year. And Table 3 shows how the division's staff have increased over the same period, with a commendable increase in efficiency. I won't take you to those tables so that they're there for everybody to see if they wish to. The growing workload has brought problems. In particular, the time taken to deal with an application, measured from its receipt to the grant of license, has grown to embarrassing dimensions. A further table is given to show that. These times currently considerably exceed the periods stipulated in EC directives, yet they are not necessary for the careful scrutiny of the data submitted, nor do they contribute to its rigorous assessment. Indeed, the public is the loser because new medicines take so long to get into the patient's hands. The delays are also commercially detrimental to the applicant companies. When it is remembered that a fairly run-of-the-mill new medicine might earn $1 million a year, and a very successful new active substance perhaps $50 million per year during its short patent life, it can be seen that each additional month's delay in issuing licenses is costing companies thousands, even millions of pounds annually. And of course, the taxpayer has an interest in a thriving UK pharmaceutical industry. Paragraph 2.6 makes the point that delays of this kind are not confined to the UK, but are also found elsewhere. And then if we go, please, to the following page, page 13, which is the chapter on complaints and findings. I'm not going to go through all of the findings of the report or all of its recommendations, but this does, so I think, help to show a snapshot of what people were thinking about some aspects of the licensing system at the time when this report was being prepared in about 1987. Paragraph 3.1. In this and the following chapter, we summarise the current problems in relation to the control of medicines as perceived by those we consulted. I pause there to say so there is a list of those who were consulted at the back of the report. Discuss our own findings and conclusions about the strengths and weaknesses of the existing arrangements. Many of these conclusions are critical. Necessarily, we give the criticisms full weight and space, for they are the foundation on which we have built our recommendations for improvement. But it is important to remember, when reading them, that overall, the record of the medicines control in the UK is a good one, and its reputation stands deservedly high. All countries have problems with delays and bureaucracy, and notwithstanding their complaints, the consensus of those we consulted was that the UK system is still one of the best in the world. It is by no means the slowest, and its record in protecting the public without inhibiting therapeutic innovation and progress is second to none. What follows, then, is intended as constructive criticism to help make a good system better. The principal complaints and difficulties made known to us were 3.2.1 by senior management of the DHSS, increasing workload is causing overload of delays, too many applications are incomplete, slovenly, or premature, imposed constraints, for example, the Treasury headcount, forbid taking on necessary staff, difficulty in recruiting suitably experienced professional assessors, Appeals against licensing refusals are very time-consuming. So that's what the senior management of DHSS said. The consumer interests, so-called, said that the legislation was more favourable to the health of the pharmaceutical industry than to the health of the consumer. More medicines are approved than are needed. Undue secrecy about the nature and working of the medicines control process. Undue secrecy about the grounds on which licensing decisions are taken. And flaccid enforcement of the legal powers about promotion and advertising. The complaints by the industry were of delays and over-formalised procedures with too little informal communication, overzealous pursuit of unnecessary detail, nitpicking, professional assessors lack experience, and frequent errors in documentation. The principal complaints and difficulties from the staff of the medicines division were of the poor quality of many applications, the lack of secretarial and other support for professional staff, inadequate computing and unreliable database, and the structure of the division impedes good working and effective management. And finally, on the following page, principal complaints by others, the scope of the legislation should be extended to bring additional items under control. Then if we go to paragraph 3.4, the report's authors talk about where there weren't complaints. Rather to our surprise, there were two significant omissions from the list of criticisms. Even though we gave ample opportunity for the issue to be raised, those we consulted did not particularly condemn the amounts of data required in support of licence applications for new drugs. And we found that although many of those we consulted would like to see the Medicines Act changed in one respect or another, some favouring tightening its provisions, others the reverse, there was almost universal reluctance to see its amendment, lest more be lost than was gained by disturbing the present balance of conflicting interests. Those then are the types of criticisms that the report's authors received during their work. I stress this is from 1987, so it is a snapshot in time, and it may not apply earlier, it may not apply later. I also stress that this is a report into the licensing of medicinal products broadly, across the board, and not just blood products. Finally, sir, if we could go to page 6 and 7, please, Sir Nick. Page 6, sorry, 6 and then 7. Could we have page 7 on the split screen with it, please? I won't go through all of these, sir, but these are a summary of the recommendations that were made. And you can see that they are divided into organisational recommendations, new technology, staffing and personnel, improved procedures. And then if we go, I won't ask for it to be brought up, but there's also recommendations about expert drug reaction monitoring, expert advisory committees, appeals and finance. So that is the series of recommendations that the report made. I confess I haven't followed through precisely how they were implemented, but I do note that it was a couple of years later that the Medicines Control Agency took effect within the Department of Health, taking on the work that had previously been done by the Medicines Division. That concludes the presentation that I'm giving now on licensing, the overview. Much more can and I'm sure will be said on licensing during the course of the evidence that you hear, and on the other functions of some of the bodies that we have mentioned. But for now, I will leave it there. I note the time, sir, and we'll be moving on to the pharmaceutical companies shortly.
Yes, well, we'll take a break until 10 to 12. Sorry, actually, quarter to 12.
Thanks, sir.